Massachusetts has a complex and evolving rent increase landscape that combines strong statewide tenant protections with active local efforts to regulate rental pricing. If you manage rental property in Massachusetts, the framework is more restrictive than you might expect, and the political trajectory is clearly moving toward more regulation. The governing law is found in Massachusetts General Laws, Chapter 186, which covers landlord-tenant relations, along with local ordinances and initiatives that have reshaped the conversation around rent increases in the Commonwealth. Let's start with the statewide framework. Massachusetts does not currently have a statewide rent control statute that caps the dollar amount or percentage of a rent increase. A landlord outside of any local rent regulation program can technically raise the rent by any amount, provided they follow proper procedures and the increase isn't motivated by an illegal purpose. However, Massachusetts has a complicated history with rent control. Boston, Cambridge, and Brookline all had rent control programs that were in effect for decades, some dating back to the 1970s. These programs were eliminated in 1994 when Massachusetts voters narrowly approved a statewide ballot question that banned rent control across the Commonwealth. The ban was codified in General Laws, Chapter 40P, which prohibits any city or town from enacting, maintaining, or enforcing rent control. This statewide ban means that currently, no Massachusetts municipality can impose rent caps, regardless of local political sentiment. Boston, Cambridge, Somerville, and every other Massachusetts community are legally barred from implementing rent control under the existing statute. But here's where it gets interesting. The ban has been under sustained political attack in recent years. Multiple bills have been filed in the Massachusetts legislature to repeal the statewide ban and allow municipalities to enact their own rent stabilization programs. Boston's city government has publicly advocated for the authority to implement rent control. Cambridge, Somerville, and other communities have expressed similar interest. The political momentum behind repeal efforts is substantial, driven by the state's extreme housing costs and widespread affordability challenges. While repeal has not yet been enacted, landlords in Massachusetts should treat this as an evolving situation rather than a settled one. If the statewide ban is repealed or modified to allow local option rent control, Boston and several other communities would likely move quickly to implement their own programs. Monitoring the state legislature's activity on this issue is essential for any Massachusetts landlord planning their long-term investment strategy. For tenancies at will, Massachusetts' term for month-to-month arrangements, the landlord must provide advance written notice before a rent increase takes effect. Massachusetts requires at least one full rental period or 30 days notice, whichever is longer, before a rent increase becomes effective. In practice, for monthly tenancies, this means at least 30 days notice. So if rent is due on the 1st and you want the increase to take effect on May 1st, you need to deliver the notice by April 1st at the latest. The notice must be in writing and should clearly state the current rent, the new rent amount, and the effective date. Massachusetts doesn't prescribe a specific statutory form for rent increase notices, but the notice should be clear, professional, and delivered by a documented method. Acceptable delivery methods include personal delivery and leaving a copy at the tenant's last and usual place of abode. Here's something important about Massachusetts. The notice to increase rent on a tenancy at will is essentially creating a new tenancy at the higher rate. If the tenant accepts and pays the higher amount, the new rate is established. If the tenant refuses and continues paying the old rate, the landlord's options depend on the circumstances. The landlord can accept the old rate and continue the tenancy at the original price, or the landlord can serve a proper notice to quit and pursue eviction. But this brings all of Massachusetts' robust tenant protections into play, including the habitability defense under Section 8A that we discussed in our Massachusetts lease termination video. For fixed-term leases, the rent is locked in for the duration of the lease term unless the lease includes a provision allowing midterm increases. Without such a provision, the landlord must wait until the lease expires to negotiate a new rent. When the lease approaches expiration, the landlord should communicate the proposed new rate with sufficient advance notice for the tenant to evaluate and respond. If the tenant doesn't agree to the new rate, the lease expires at its natural end. If the tenant stays and the landlord accepts rent, the tenancy converts to a tenancy at will, subject to the standard notice requirements for future changes. For week-to-week tenancies, the notice period for rent changes is at least 1 week. Now let's cover the restrictions that apply statewide. And Massachusetts has some of the strongest tenant protections in the country that indirectly affect rent increases. Rent increases cannot be retaliatory. Massachusetts has one of the strongest anti-retaliation statutes in the nation under Section 186, Section 18. A landlord cannot increase rent in retaliation for a tenant exercising any legal right, including making a repair request, filing a complaint about habitability with the Board of Health or any government agency, withholding rent due to conditions, participating in a tenants organization, or exercising any right under Massachusetts law. Massachusetts' anti-retaliation provision creates a rebuttable presumption of retaliation if the landlord takes adverse action within 6 months of the tenant's protected activity. 6 months is a significant protection window. Any rent increase delivered within that period after a tenant's complaint carries an automatic presumption of retaliatory motive. The landlord must overcome this presumption by proving that the increase was motivated by legitimate business factors entirely unrelated to the tenant's complaint. The consequences of a retaliatory rent increase in Massachusetts are severe. The tenant can recover actual damages or 3 months' rent, whichever is greater, plus costs and attorney's fees. And here's the critical additional exposure. Massachusetts Consumer Protection Statute, Chapter 93A, can be invoked in landlord-tenant disputes involving unfair or deceptive practices. If a retaliatory rent increase is found to violate 93A, the tenant can recover treble damages, meaning 3 times the actual damages, plus attorney's fees. This triple damages exposure makes retaliatory rent increases extraordinarily risky in Massachusetts. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the Massachusetts Fair Housing Law, found in General Laws Chapter 151B, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, sexual orientation, gender identity, disability, familial status, marital status, age, ancestry, genetic information, or military service. Massachusetts' anti-discrimination protections are among the broadest in the country. The Massachusetts Commission Against Discrimination investigates fair housing complaints and can take enforcement action. A discriminatory rent increase can result in significant liability, including compensatory and punitive damages. Massachusetts also has a specific protection related to source of income that affects rent increases. Under the state's anti-discrimination provisions, a landlord cannot raise rent specifically to target or push out a tenant who receives Section 8 vouchers, public assistance, or other lawful sources of income. A rent increase that appears designed to drive out subsidy recipients, while other comparable tenants are not similarly affected, can result in a discrimination complaint. The habitability defense creates another important restriction on rent increases in Massachusetts. As we covered in our Massachusetts lease termination video, Section 8A of Chapter 239 provides that if a landlord's property has unresolved code violations, the tenant can raise habitability as a defense in any eviction proceeding, including an eviction based on non-payment of a rent increase. This means that if a landlord raises rent and the tenant refuses to pay the increase, and the landlord then files for eviction based on non-payment, and the property has code violations, the court may reduce the rent owed or dismiss the eviction entirely. The practical implication is that Massachusetts landlords must ensure their properties are in full code compliance before implementing any rent increase. Raising rent on a property with unresolved habitability issues is legally counterproductive. You can't enforce the increase if the tenant can point to code violations as a defense. From a practical standpoint, Massachusetts has one of the most expensive rental markets in the country, concentrated heavily in the greater Boston area. Boston itself has some of the highest rents in the nation, driven by healthcare, including the world-renowned hospital and research cluster, higher education, including Harvard, MIT, Boston University, Northeastern, and dozens of other institutions, technology, financial services, and biotech. Boston's neighborhoods offer a wide range of price points. The Seaport, Back Bay, and Beacon Hill command premium rents, while neighborhoods like Dorchester, Mattapan, and East Boston are more moderate but still expensive by national standards. Cambridge, directly across the Charles River from Boston, has an extremely tight rental market driven by Harvard, MIT, and the Kendall Square Biotech and Technology Cluster. Rents in Cambridge are among the highest in the state, and demand consistently outpaces supply. Somerville, Brookline, Arlington, and the inner suburbs have seen dramatic rent growth as the Boston area's housing shortage has pushed demand outward. These communities have active tenant advocacy populations and have been at the forefront of the rent control repeal conversation. Worcester, Massachusetts' second-largest city, has experienced significant rent growth in recent years, as residents priced out of Greater Boston have moved west along the I-90 and commuter rail corridors. What was once an affordable alternative to Boston now has rents that would have been unimaginable a decade ago. Landlords in Worcester have seen strong pricing power, though the market is more price-sensitive than Boston. Springfield and the western Massachusetts communities have more affordable rental markets, though rents have increased across the state. The Five College area, including Amherst, Northampton, and South Hadley, has a tight market driven by the University of Massachusetts, Amherst College, Smith College, Mount Holyoke College, and Hampshire College. The Cape Cod and Islands region has a unique seasonal rental market with extremely high summer rents and more moderate year-round pricing. The seasonal worker housing shortage has been a persistent issue on the Cape and Islands. One critical best practice for Massachusetts landlords: ensure full code compliance before implementing any rent increase. Order a pre-increase inspection of the property, address any deficiencies, and document the property's condition. A rent increase on a property with unresolved code violations is essentially unenforceable in Massachusetts because of the Section 8A defense. Another best practice, given the 6-month anti-retaliation presumption and the treble damages exposure under Chapter 93A, maintain meticulous documentation of the business justification for every rent increase. Keep records of market comparables, operating cost changes, property tax bills, insurance premiums, and capital improvements. If a tenant has made a complaint within the past 6 months, your documentation must clearly demonstrate that the increase was planned independently and is consistent with your treatment of other comparable units. For landlords watching the rent control debate, consider the potential impact on your investment strategy. If the statewide ban is repealed and local rent control returns to Boston or Cambridge, properties in those jurisdictions could see significant regulatory changes that affect future revenue growth. Some landlords are factoring this political risk into their acquisition and development decisions. Massachusetts requires landlords to return the security deposit within 30 days of the tenant vacating. The deposit must be held in a separate interest-bearing escrow account at a Massachusetts bank, and the tenant is entitled to receive interest annually. The landlord must also provide a receipt for the deposit and a statement of the property's condition at the beginning of the tenancy. Failure to comply with any of these requirements, including the escrow, receipt, condition statement, or timely return, can result in the landlord being liable for treble damages plus attorney's fees under both the security deposit statute and Chapter 93A. Massachusetts limits the security deposit to 1 month's rent. For Massachusetts landlords who participate in the Housing Choice Voucher Program, Rent increases must be approved by the local housing authority. The authority evaluates whether the proposed rent is reasonable by comparing it to comparable unassisted units. Given the state's source of income protections, the interaction between voucher program rules and anti-discrimination law adds an important compliance layer. Submit increase requests well in advance of the desired effective date. For the complete guide to Massachusetts rent increase laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel so you stay protected in every state.